Welcome back to Lakeside Legends, where we share the most unbelievable stories of property disputes, entitled neighbors, and justice served with a side of poetic irony. Today's story is so incredible that you might think it's fiction, but every word is documented truth. We're talking about an HOA that literally built a private beach resort on someone else's lake, complete with a clubhouse, dock, and swimming area, only to discover they'd been trespassing on private property the entire time. Imagine waking up one morning to find that your peaceful private lake has been transformed into a bustling community beach, complete with hundreds of strangers in swimsuits treating your family's century-old property like their personal vacation resort. What would you do when the HOA tells you that you're trespassing on what they claim is community property? Well, stick around because this story has the most satisfying legal twist involving century-old land grants, mineral rights, and a courtroom revelation that left an entire HOA board speechless. Our story unfolds at Willow Pond Estates, a luxury subdivision built around what developers marketed as pristine lake access in northern Minnesota. The community was designed for wealthy retirees and vacation homeowners who wanted the quintessential lake life experience without actually owning lakefront property. Meet Kate Morrison, a 45-year-old environmental lawyer who inherited her great-grandfather's 160-acre property, including the entirety of Crystal Lake, a pristine 40-acre body of water that had been in her family since 1887. Kate was methodical, well-educated in property law, and had a deep connection to the land that her Scottish immigrant ancestors had homesteaded over a century ago. Then there's Preston Blackwood III, the 58-year-old developer who created Willow Pond Estates and served as the community's HOA president. Preston was old money from Minneapolis who treated rural Minnesota like his personal playground. He drove a Tesla, wore designer casual wear to community meetings, and believed that money could solve any problem, including inconvenient property ownership issues. Supporting this lakeside drama was Amanda Chen, the 35-year-old HOA manager who executed Preston's vision with ruthless efficiency. Sheriff Tom Bradley, a local lawman who understood both property rights and community politics, and Judge Margaret Henley, whose family had been settling property disputes in the county for 3 generations. Kate had been living quietly on her family's property for 2 years, working remotely as an environmental consultant while slowly restoring the century-old farmhouse her great-grandfather had built. The property was a naturalist's dream. Untouched forest, pristine wetlands, and Crystal Lake sitting like a jewel in the center of it all. Crystal Lake was special. Fed by underground springs and completely surrounded by Kate's property, it was a rare example of a completely private lake. Her great-grandfather's homestead documents, dating to 1887, specifically included mineral and water rights to the entire lake and surrounding watershed. Kate used the lake respectfully. Early morning kayaking, evening fishing, and occasional swimming. She had installed a small dock for her canoe and maintained a narrow trail through the woods for access. It was exactly the kind of peaceful, sustainable lifestyle she had dreamed of when she left her high-stress Minneapolis law firm. The problems began when Preston Blackwood started developing the land adjacent to Kate's property. She had heard rumors about a new subdivision, but Preston's representatives assured her that the development would respect existing property boundaries and environmental concerns. What Kate didn't know was that Preston had been planning something much more ambitious. He had marketed Willow Pond Estates as a lakefront community and sold 200 lots at premium prices based on promised lake access. His marketing materials featured beautiful photos of Crystal Lake and promised residents exclusive community beach facilities. The first sign of trouble came when Kate noticed increased traffic on the county road that bordered her property. Then she started seeing survey stakes appearing near her lake, followed by construction equipment moving through the woods. Kate called Preston's development office to inquire about the activity. Amanda Chen, the HOA manager, was politely evasive. Ms. Morrison, we're just doing some preliminary site preparation for community amenities. Nothing that should affect your property. What kind of community amenities? Oh, just some recreational facilities for our homeowners. Preston will be happy to discuss it with you once the planning is finalized. Kate didn't like the sound of that, but she was deep into a complex environmental lawsuit for a client and didn't have time to investigate immediately. That would prove to be a costly mistake. 3 weeks later, Kate woke up at dawn for her usual morning kayak only to discover that her private lake had been transformed overnight. Where yesterday there had been natural shoreline and peaceful water, Today there was a construction site that looked like a resort development. Someone had built a 200-foot sandy beach where her natural wetlands used to be. There was a large wooden dock extending into the lake, a concrete boat ramp, and what appeared to be the foundation of a substantial building. Construction crews were already at work at 6 a.m., installing picnic tables and playground equipment. Kate threw on clothes and marched through the woods to confront whoever was in charge. She found Amanda Chen standing near a surveyor's transit, directing workers with the confidence of someone who owned the place. "Excuse me. What the hell is going on here?" Amanda looked up with practiced professional calm. "Good morning. You must be Ms. Morrison. I'm Amanda Chen, Willow Pond Estates HOA manager. We're installing community recreational facilities as outlined in our development plan. This is my property. You're trespassing on my land and destroying my wetlands." Amanda consulted her clipboard with theatrical precision. "Ms. Morrison, I think there's been some confusion. According to our surveys, this lake and the surrounding 50 feet of shoreline is designated community property under the Willow Pond Estates Community Charter." Kate felt her environmental lawyer instincts kicking in. "Show me your surveys and your legal documentation for that claim." "I don't have those documents with me, but they're all properly filed with the county. Preston Blackwood can explain the details when he returns from Minneapolis next week. I want all work stopped immediately until we resolve this property dispute." Amanda's smile remained professional but cold. "Ms. Morrison, I understand your concern, but we have proper permits and legal authority to proceed. The Community Beach Project represents a significant investment in property values for all residents." "All residents? I'm not a resident of your community. Actually, according to our legal research, your property is surrounded by Willow Pond Estates and should have been included in the original community incorporation. There may have been a filing error that we're prepared to help resolve." Kate realized she was dealing with people who had either made a massive legal error or were attempting some kind of sophisticated property theft. Either way, she needed to act quickly before more damage was done. "Stop all work immediately or I'm calling the sheriff." Amanda gestured to the construction crew, who continued working. "Ms. Morrison, you're welcome to call anyone you like, but we have legal authority to proceed with community improvements on community property." Kate called Sheriff Tom Bradley, who arrived within an hour to find what looked like a small army of construction workers building a resort on the shoreline of Crystal Lake. Sheriff Bradley had grown up in the county and remembered when the Morrison family had owned the entire area. "Kate, what's the situation here?" Kate explained about waking up to find her private lake turned into a construction site. Amanda Chen immediately approached with her folder of official-looking documents. "Sheriff, we have proper permits for this community beach project. Ms. Morrison seems confused about property boundaries." Sheriff Bradley examined Amanda's documents, which included building permits, environmental permits, and what appeared to be a property survey showing the lake as community property. "Kate, I'm going to need to see your property documentation. Amanda, I'm going to need to see your surveys and legal authority for this work." Kate provided her deed, which clearly showed ownership of the entire lake and surrounding property. But Amanda's documents appeared official and included what looked like legitimate county permits. "This is going to require legal resolution," Sheriff Bradley concluded. "Kate, I can't stop work on what appears to be properly permitted construction without a court order. Amanda, if Kate can prove she owns this property, you're looking at serious criminal charges for destruction of private property." That afternoon, Kate drove to the county courthouse to research the property records herself. What she found was a carefully constructed legal fraud that had taken months to execute. Someone had filed a series of documents with the county claiming that Crystal Lake was a navigable waterway subject to public access rights. They had then filed incorporation papers for Willow Pond Estates that included the lake and surrounding area as common property transferred from undocumented ownership. The documents were sophisticated forgeries that had fooled county clerks, but Kate's trained legal eye spotted the problems immediately. The signatures were wrong, the legal descriptions didn't match historical surveys, and most damaging of all, the filings ignored the mineral and water rights that were clearly documented in her great-grandfather's original homestead grant. Kate spent the weekend researching and preparing her legal response. What she discovered was that Preston Blackwood had been planning this theft for over a year, carefully filing false documents and building a paper trail to support his claim to her lake. But Preston had made one crucial error. He hadn't researched the historical documentation carefully enough to understand that Kate's family didn't just own the surface rights to the property. They owned the mineral rights, water rights, and subsurface rights granted under the original 1887 Homestead Act. Under Minnesota law, those historical mineral and water rights were almost impossible to challenge and took precedence over any subsequent development claims. Kate literally owned everything under, on, and above Crystal Lake going back 130-plus years. Armed with this information, Kate filed an emergency injunction in county court, demanding immediate cessation of construction and removal of all improvements from her private property. She also filed criminal complaints for trespassing, destruction of property, and fraud. The emergency hearing was scheduled for the following Monday. Preston Blackwood returned from Minneapolis with a team of expensive lawyers, confident that his carefully constructed legal framework would protect his development. The courtroom was packed with Willow Pond Estates residents who had been promised exclusive lake access and were now facing the possibility that they'd been sold a lie. Preston's legal team presented their case first, arguing that Kate's property claims were outdated and superseded by proper development procedures. Your Honor, Preston's lead attorney argued, the defendant's claims are based on century-old documents that predate modern property law and zoning regulations. Our client has followed all proper procedures for community development and has invested over $2 million based on legitimate legal authority. Kate represented herself, which surprised everyone in the courtroom. As an environmental lawyer, she was comfortable in court, but property law wasn't her specialty. However, she had spent the weekend becoming an expert in Minnesota homestead law and mineral rights. Your Honor, I'd like to present evidence that the plaintiff has committed systematic fraud in filing false documents with the county and has trespassed on clearly documented private property. Kate's first exhibit was her great-grandfather's original homestead grant, signed by the territorial governor in 1887. The document was beautifully preserved and clearly granted ownership of the entire 160-acre tract, including all water rights, mineral rights, and subsurface rights in perpetuity. Her second exhibit was a series of photographs showing Crystal Lake before and after Preston's construction, documenting the environmental destruction of protected wetlands. But her third exhibit was the knockout punch, a complete analysis of the forged documents that Preston had filed with the county, including expert testimony on the falsified signatures and legal descriptions. Your Honor, the plaintiff has systematically filed false documents with this county in order to steal private property and defraud homeowners who purchased lots based on promised lake access that the plaintiff had no legal right to provide. Judge Margaret Henley had been reviewing the documents during Kate's presentation, and her expression grew increasingly grim. The Henley family had been judges in the county for generations, and Margaret knew the historical property laws better than most. Mr. Blackwood, I've reviewed all documentation presented, and I have serious concerns about the legal foundation of your development claims. Can you provide any evidence that Ms. Morrison's family ever sold, transferred, or relinquished their water rights to Crystal Lake? Preston's attorney looked uncomfortable. Your Honor, we believe those historical claims are superseded by modern zoning and development regulations. Counselor, mineral and water rights granted under territorial homestead acts are some of the strongest property rights in Minnesota law. They don't get superseded by zoning changes or development wishes. Judge Henley continued, furthermore, I'm looking at what appears to be a systematic attempt to falsify county records and defraud both Ms. Morrison and your own homeowners. This case is being referred to the district attorney for criminal investigation. The courtroom erupted. Willow Pond Estates residents realized they had been sold lots with promised amenities that didn't legally exist. Preston's lawyers were frantically conferring, trying to salvage a situation that was collapsing rapidly. Judge Henley issued her ruling: immediate cessation of all construction on the disputed property, removal of all improvements within 30 days, restoration of damaged wetlands, and full criminal investigation of the document fraud. But the story was far from over. The criminal investigation revealed the full scope of Preston's scheme. He had sold 200 lots for an average of $150,000 each based on promised lake access, generating $30 million in sales. The community beach and exclusive lake rights were central to his marketing and pricing. When criminal investigators examined Preston's files, they found emails discussing the Morrison problem and strategies for acquiring lake rights through adverse possession and creative legal interpretation. Most damaging was an email from Preston to Amanda Chen. The Morrison woman won't know what hit her. By the time she figures out what we're doing, we'll have established community use and possession. Rural property owners never have the resources to fight us in court. That email became evidence of conspiracy to commit property theft and fraud. The criminal trial was a sensation. Preston Blackwood, scion of Minneapolis society, faced multiple felony charges for property theft, fraud, and environmental destruction. Amanda Chen was charged as a co-conspirator, along with several contractors who had knowingly participated in the illegal construction. The prosecution's case was devastating. They proved that Preston had deliberately researched Kate's property, identified the valuable lake rights, and devised a scheme to steal them through false documentation and fait accompli construction. The environmental damage was particularly serious. Crystal Lake's wetlands were habitat for several protected species, and the illegal beach construction had violated multiple state and federal environmental laws. Preston's defense was that he had relied on legal advice and believed his claims were legitimate, but the email evidence contradicted this completely. The jury took 4 hours to convict on all counts. Preston received 5 years in state prison and was ordered to pay $3.2 million in restitution to Kate for environmental restoration, legal fees, and damages. Amanda Chen received 2 years and $500,000 in fines. The civil lawsuit against Willow Pond Estates HOA and Preston's development company resulted in a $15 million judgment. The HOA was forced into bankruptcy, and most of the homeowners lost their investments when the promised lake access proved to be fictitious. But the story's most satisfying twist came during the property restoration. When environmental crews began removing Preston's illegal beach construction, they made an unexpected discovery. Crystal Lake sat on top of a significant iron ore deposit that had been missed in historical mining surveys. Kate's mineral rights, inherited from her great-grandfather's homestead grant, now included ownership of an iron ore deposit worth an estimated $40 million. Preston's attempt to steal her lake had inadvertently led to the discovery that she owned one of the most valuable undeveloped mineral deposits in northern Minnesota. Kate used the mineral rights discovery to fund a complete environmental restoration of Crystal Lake and the surrounding watershed. She established a conservation trust that would protect the property in perpetuity while providing sustainable income for environmental protection. The story became a cautionary tale in property law schools and a rallying cry for environmental protection advocates. Kate's successful defense of her family's century-old property rights inspired similar cases across the country. Sheriff Tom Bradley received a commendation for his professional handling of the case and his support for thorough investigation over expedient resolution. He was later elected to the County Commissioner Board on a platform of protecting rural property owners from development fraud. Judge Margaret Henley's ruling became precedent for similar cases involving historical property rights and development fraud. She was later appointed to the State Appeals Court, where she continued to defend property owners against corporate overreach. The Willow Pond Estates development was eventually sold to a conservation organization and converted into a state park, with Crystal Lake serving as the centerpiece of a protected wilderness area. The moral lessons from this incredible Minnesota tale resonate across multiple dimensions. First, never underestimate the power of historical property rights, especially those involving mineral and water rights granted under territorial or homestead acts. These rights are often more powerful than modern property owners realize. Second, criminals often create the very evidence needed to convict them. Preston's email communications and systematic document falsification provided prosecutors with a clear paper trail of criminal intent and conspiracy. Third, environmental destruction can carry criminal penalties that far exceed simple property damage. Preston's wetlands destruction triggered federal environmental crimes that added years to his sentence. Fourth, sometimes the best defense is a thorough understanding of property law and the willingness to do your own legal research. Kate's environmental law background gave her the skills to uncover the fraud that expensive attorneys might have missed. Finally, the story demonstrates that justice sometimes comes with unexpected bonuses. Kate's fight to protect her family lake led to the discovery of mineral wealth that ensured the property's permanent protection. Today, Crystal Lake sits pristine and protected at the center of what is now Morrison Conservation Area, a state park that honors both environmental protection and historical property rights. Visitors can kayak on the same waters that Kate's great-grandfather fished over a century ago. Kate still lives in a restored farmhouse, now serving as a consulting environmental lawyer who specializes in helping rural property owners understand and protect their historical rights. She often tells visitors that her great-grandfather would be amazed that his small homestead became the center of a battle that protected property rights for property owners across the state. And somewhere in a state penitentiary, Preston Blackwood III probably still wonders how his foolproof plan to steal a private lake ended up costing him everything. The answer, of course, is simple. He forgot that some property rights are literally carved in stone, dating back to when Minnesota was still a territory and land grants came with powers that modern developers can't imagine. Sometimes the best revenge isn't revenge at all. It's simply letting a criminal's own greed and arrogance provide all the evidence needed for justice to prevail.